God. So next, we are going to discuss from section 57 to 59. This is regarding amendment of application and specifications. So many times, many questions are asked on the amendment part, and this is very important section. Okay, so section 57, amendment of application and a specification or any document related thereto before controller. Okay, and then next is before appellate board or high court, and then section 59 actually summarizes what are the kind of changes that can be done. So section 57 says subject to section 59. Okay, so section 59 says supplementary provisions as to amendment of applications or a specification. Okay, so there all the conditions are mentioned, what are the changes can be done. So all changes are subject to this section 59. So therefore it reads, subject to provisions of section 59, controller may allow modification if application is made. And then what you need to do if you want to do amendment, but we will read section 59, what are the amendments can you do. But if you want to make those amendments under certain condition to the controller, then we need to fill form 13. And for more details, you can read rule 81. And if before grant, then fees 800 and 4,000 for others. If after grant, then fees is 1,600 and 8,000 for others. And for changing name or address or nationality or address of service, then 320 for naturals and 1,600 for others. And what you need to do, that you need to state the nature of amendment, and an application for amendment after grant shall be published. So if you want to change the name, if you want to change the address, if you want to change the nationality, anything you want to change, and that is after the grant, then controller will publish that this is the patent applications and the other changes is going to happen. So why controller is publishing? So that any person interested may file for opposition for amendment. Okay. So government is giving chance to any person interested. Always remember, person and any person interested, both are different. So we have been discussing person interested many times. So please keep in mind, this person interested is different. So you may get a question saying that a person can oppose for the amendment after the grant. A person interested can oppose. So if it says a person interested, that is the correct. If it says a person, then that is not correct. Okay. Then priority date may also be amended. So if for any reason you want to amend the priority date, that also you can do under these provisions. And then says applicant may amend patent on direction of controller issued before the grant of patent. So when the FAR is issued and controller asks us to amend something in a specification or something, anything that he wants, that also can be amended according to section 57. So this is regarding amendment before the controller. What rule 81 says, that if amendment is required before the grant, controller can take decisions. If amendment is required after the grant, nature of amendment is published. Okay. So if amendment is done before the grant, then controller will do it. It will not get published. So nature of amendment is not published if it is done before grant. But if amendment you're asking after the grant, it get published. Okay. So because after the grant document get published, and say for example it is under my name, and then you understand that publication was in my name, and then suddenly I want to change those names and some addresses, and then if I'm a person interested and my business is getting hampered because of these changes or any decisions, or I don't know, I don't have any case study to understand, but you can understand like this, that a person interested may be affected by some changes, and then he has right to oppose, and I will read what he can do. So any person interested can file notice of opposition in form 14. So if you are a person interested, then you can file a notice of opposition in form 14. What is the time? Time is within 3 months from date of publication of the application, and fee is 2,400 and 12,000 for others. And what is the hearing procedures? Hearing procedures same as rule 57 to 63 that we have discussed in the post grant opposition. So please remember that post grant opposition step-by-step processes, how the documents are submitted, then the patentee submits documents, and then there is no further submission documents, and thereafter controller will call for the hearing. Then during the hearing we can bring some more documents, and so all those steps you need to remember from rule 57 to 63 that we have discussed during the post grant opposition. So that steps is varied for many different cases. So if you remember once, then it's done for all the places. And I have tried to mention this hearing procedures wherever it's mentioned there. So rule 81. So regarding patent of regarding amendment of applications for section 57, these are the things that you need to keep in mind and understand. So basic thing that always subject to section 59. So we'll read in section 59 what are the kind of changes that can be done. But if you want to make before the controller, so there is some like you can form 13 is used before the grant, after the grant. If you are going to make any changes after the grant, then that will get published. And so if you don't want to get into the cycle of oppositions and all those things, it is preferred that you try to make any changes that is required before the grant of patent. Otherwise, you never know that after the grant, if you're going to make any changes, then any person interested can come and oppose the patent within 3 months. So up to 3 months of the publication, you have the chance that it is getting opposed. So what I say that if we have a patent applications, you want to make any changes, then you fill form 13, pay the fee of 800 or 1600 if it is after a granted, then 1600 and 8,000 for companies, other corporates. And if it after the grant, then for 3 months you have a risk period. Means anyone can oppose. And how to oppose this? To fill form 14 and then pay the fee. So if I want to oppose, I need to pay the fee, and then all the proceeding will be done. And after the outcome of these proceedings, only it will get changed. And if in the proceedings a person interested wins the argument, then whatever changes I want to do, that change will not be allowed. And if the patentee wins, then that changes will be there. But again, back and forth hearing, you have to go to controller, then many things get into picture. So it is always good that if you make any changes before the grant. But there are many cases that you can't control, and then after the grant you have to make changes. Then these are things are done. Nationality gets changed. For example, one patentee was there, one inventor was there. He was earlier Indian, Indian citizen, but after the grant, already 5 years has passed, and then he changed his citizenship to some other country. He went to other country, took citizenship there. Then I need to change the nationality of that inventor as well there. So that is the case. Okay. Section 58. Amendment of a specification before appellate board or high court. So any changes before the controller we discussed. Now we are going to discuss on before the appellate board or high court. So again it says subject to section 59. So read, during the proceedings for revocations under appellate board or high court, they may allow amendment of a specification instead of revoking the patent. So we'll read more details on revocation of patent. So what it says that if in my specification there are certain things, for example, if I claim some fissionable materials, okay, then government can come and say that please revoke this patent. But this fissionable material is just one part of the claim. So if I agree that okay, I'm ready to remove these sections from my application, I'm not going to claim the fissionable material, then that changes will be allowed. So this is what it says. During the proceeding for revocations under appellate board or high court, as the case maybe we'll read what are the revocation goes to appellate board and what goes to high court. It will come later. But here the point to understand is that if it is for revocations and then patent has to revoke, but if the patentee says that I'm ready to remove or amend my applications, my specifications, then they may allow this. If appellate board or high court asks to amend, the applicant will inform controller. So what is the process? So during the hearing, appellate board or high court, they may issue that this need to be amended, and the applicant will inform the controller regarding the decisions of the appellate board or the high court, and the controller may appear in hearing if asked by the appellate board or high court. It says this that in such kind of hearing, controller may appear if a high court orders him to appear, and the copy of the order or for the amendment is given to controller. Okay, so that's all in section 58. 59 is the important one for our understanding. What it says that supplementary provisions as to amendment of application or a specification. So what are those? Here these are. It's a very long paragraph. I have broken down into simpler wordings. Amendment is made by way of disclaimer, corrections, explanations. No amendment thereof shall be allowed except for incorporation of actual facts. So you can amend to incorporate actual facts in the documents. No amendment of complete specification shall be allowed. Okay, the will not be allowed. The effect of which would be that the specification as amended would claim or describe matter not in substance disclosed or shown in a specification before amendment, or any claim of the amended specification would not wholly be within the scope of a claim of previous specification before amendment. So, for example, if I say very broad, I would say, so initially I had claimed iron. Okay. Now, if I say I want to amend this and say all metals, all metals. So I can't say all metals. Okay. So all metals, initially I had only iron, and then I want to broaden this up and include all metals. This I cannot do. Okay. Not wholly within the scope of the claim of the previous specification before amendment. Okay. So all metals are not within the scope because initially I had only iron. Now I want to claim all metals. This I cannot do. Okay, this is the meaning. Especially as amended would claim or describe matter not in substance disclosed. So, for example, in the specification, we said that a catalyst containing gold, Au, silver, Ag, palladium, platinum. These things were mentioned, but iron is not mentioned, and molybdenum is not mentioned. So those things are not mentioned in substance here. Or I'm just giving very crude examples. So you cannot incorporate other things than this. Okay, sometimes we say group 7 metals, or group 7A, group 8 metals, or for example, in case of I'm from chemistry, so I know these kind of examples. I have not read many patterns on mechanical or biologicals, but you can understand in the similar fashion that matter not in substance disclosed, you cannot amend to include those. Would claim or describe matter not in substance disclosed. It should not change to that language. What are they? You can add some explanation. So, for example, if it is regarding the solution, so you can say what kind of solution. So, if you talk about the solubility, for example, if you talk about the solubility, then you may add explanation that as we know that substance there is a solubility limit is there. That means certain amount of solvent will not hold more than the saturation point. That means in 1 liter of water, you cannot add 1 kg of salt. Okay, so there is a limit of that 1 liter of water to get salt in a solubilized form. So if there is a special case and you want to talk about the solubility of your compound in any solvent and you have not added any explanation, so those kind of explanation you can add to further explain this, but you cannot make. Many times there are means errors. So you wanted to say 1 gram, but you wrote 1 kg by mistake. So this or 1 kg you wanted to write, you added 1 gram or something like this. You wanted to add 1 liter, but you wrote 1 ml. Some mistakes are there. So those things you can correct, saying that no, I didn't mean to say 1 kg, but I mean to say 1 gram. So this kind of correction are allowed because it's not changing the scope. But again, while making these changes, they will try to see if by changing gram to kg or kg to gram, you should not claim something not disclosed, or it should not claim something, because from going from kg to gram to kg, you are broadening on the scope or narrowing the scope. So it is not wholly within the scope of the claim of the previous specification before amendment. So these things are taken care. So in short, what they want to means something which you have written and given to the controller, it is very difficult to change those things. You cannot increase the scope, you cannot decrease the scope. Those things you can't do it. So that needs to you need to be very careful while drafting the patent. If any amendment, there are some typing errors, as I already told before. If any amendment is made after the grant of patent, then the amendment becomes part of the specifications. So if you make any amendment after the grant, then that amendment becomes part of a specification. That means if you narrow down the scope, then your whole scope becomes narrowed down. If you say that we are not interested in this kind of industry, then those kind of industry will completely excluded from your topic. Details of amendment is to publish as I discussed, and then within 3 months you can oppose, by filling form 14. Right of patentee to amend is not questioned except in case of fraud. So patentee has the right to amend, but they will not ask why you want to amend. Will not amend this. If there is a fraud, then they are going to ask. Otherwise, if our amendments fall within the scope of this, then it is not questioned. And during a specific amendment, reference to original specification is made, meaning when you want to amend the specification, then you need to give two specifications, okay, line by line, and then you need to say first specification, line number 10, paragraph this much, paragraph 2, line number 10, this line we want to amend it. Then you have to submit both documents so that anyone who is looking at, he can see line by line where the changes you have made. So therefore, original especially always referred. Means there will be one. This is called original. While they are going to map, this is the original, and this is the amended. So they are going to read line by line, line by line. So line number 10. Here, line number 10. What changes you have made? So you have changed gram to kg. Okay, so gram to kg change. Then they will understand this paragraph. Is your changing from gram to kg? Is increasing the scope or decreasing the scope? Is it the correction? Everywhere, say for example, everywhere the document you said gram. All where, anywhere there is a substance weight, you said gram only. And claim also you said gram. Now you said this is a typing error, I want to change to kg. Okay. So this is the complete changing from gram to kg. So then you may have some problem. You have to justify and then you may not get that change allowed. But for example, everywhere it was, a whole specification is talking about the grams of documents, and suddenly we say we claim 1 kg. Then anyone reading the document will get surprised. Everywhere in the specification it says grams, but suddenly in the claim it says 1 kg. Is it a mistake, or you want to really claim the kg one? Then you can say, no, it is, sorry, I'm very sorry, this is a mistake. I want to remove this K. It's only gram only, because all my explanation and the examples, everything is concerned only for the grams. In claim, I have by mistake written kg. Or for example, everywhere you talked about group 7, but then suddenly in claim you had one more extra line. So you know this is not a mistake, it becomes group 8 metals, group 8 elements. And then you're talking about group 7 everywhere in the documents. Then you realize, oh, this is the typing error. By mistake, I have this extra I. So I want to amend this. So this is the correction. And I want to add explanation. So those kind of amendments are required. So in some substance, you can understand that amendments can be done. If the controller asks us to amend, then we can amend it. We have to amend it. Otherwise, he may reject our application. And if we want to amend it, then it has to be a correction, explanation. So there could be questions asked, or there could be in the first paper, you may get a question saying that is this allowed or not? This kind of is asked. And a question is also asked saying that any request for amendment is published by controller. What would you say? True or false? Anyone can answer?
Sir, please repeat the question.
Question is, any request for amendment is published?
Actually, there is confusion. The answer is yes at this moment, but I just have one doubt. Suppose after the grant, if there is a clerical error, okay. So in that case, there is some amendment is there. So still in that case, it is published. Those cases also.
Yeah. So just to clarify, when we say published, it means that controller will publish that such and such person is requesting for the amendment, and then anyone interested can oppose that. Okay, this is the meaning of published. So if I go back to 57, okay, so what it says that if amendment is required after grant, the nature of amendment is published. So anyway, the document as a whole amendment is get published in the public domain, but that is the not meaning of the publication document. Publication of amendment means that in the patent office website, you will see that a request for amendment has been done, and these are the amendment they are asking, that is get published. So anything you want to make changes after the grant, controller will make a document and publish in the website that this is the changes is being asked, and then after 3 months time period, anyone can oppose in form 14. But if the amendment is done before the grant, then amendment will be done, completed, and the after the grant document will get published. That is the normal case. Document is get published. But what were the I have applied for the amendment, that request is not published. So when the question says that all the amendment request for amendment is published, so it is false. All the request for amendment is not published. Only amendment request for amendment after the grant of patent, those are published. Is it clear to everyone? Please ask if you have any doubts.
Yes, sir.
Is it clear, Satish, now?
Sir,
Yes.
hello, sir.
Yes. Clear. I can hear you.
Sir, before grant also we make filing of complete specification, amendments to complete specification. So that will be available in the public domain usually. So that it comes available only after the grant. So I have just a query regarding that.
Yeah, that become available means publish means controller will not publish that request. Okay.
Okay.
Means when I ask to change something after the grant, then controller will publish
Okay.
that on the website. That
Okay.
patentee Prem is asking to amend this from kg to gram. He want to amend this amendment in this application number or this
Okay.
granted patent. So this kind of request is
Mm-hmm.
published. And when I see the document, then I can oppose. For example, I am working on group metal 7. Okay. So I am working on 7. Okay. But when this document was published, this patent was granted, it read, we claim group 8 metals. I am relieved, or thankfully, they have not claimed the group 8 metals. Okay. Group 7 metals. I am working group 7 metals. But suddenly, what I see, that this patentee, they want to change from groups 8 to 7 now.
Okay.
And then that is if it gets changed, then the claim would be, we claim group 7 metals now. And now
Okay.
is a problem for me now, because I am working with group 7 metals. Now I will oppose this patent. I will write to a controller in form number 14 saying that I oppose this change because of so many reasons. Okay, we can give many reasons why I want to oppose it. Okay, so this is the process. Okay, but anything changes, all the documents, and if it's after the then those amendment becomes the part of specifications.
Okay.
Amendment becomes part of a specification. If amendment is made after the grant of the patent, it becomes part of specifications.
Okay.
Okay.
So any amendment after the grant should be requested to the controller, right? Controller, or it's regarding affiliate board after the grant?
To the controller.
Controller only.
Yes.
Okay, fine. Yeah. Okay.
Now,
So even
before
after
the
the grant, even after the grant of a patent, we can file amendments, on file amendments. Okay, that is
yes,
a reason. Okay,
yes.
fine. Okay,
Okay.
thank
And
you.
before the grant also, if you can, if you want to amend, that also you can amend.
Mhm,
Before the grant,
mhm.
when we amend, before the grant, we can amend by ourselves,
Okay.
or if
Hmm.
controller asks us to amend. Okay.
Okay. Okay.
After the
Hmm.
grant, means once the patent is granted, means controller agrees to what we have written, and the examiner also agrees there
Yeah.
is nothing coercive there, and patent is granted. But I want to now
Okay.
make some changes there.
Hmm.
Then
Okay.
I approach to the controller, okay, fill the form,
Hmm.
okay, and then
Hmm.
as we discussed before in section
Hmm.
57 and rule 81. So I fill the form, pay the fee depending on the what are the cases are there, and then what controller will do now? Controller will publish that request that
Okay.
the inventor Prem, he wants to make
Hmm.
changes in his patent granted number this, and these are the changes he wished to propose.
Hmm.
And then for 3 months, those changes will not be done. Okay.
Okay.
Because
Okay.
3 months is a window period when anyone person interested can oppose those changes. Because, for example, I was working on metal 7, 7 group 7, and the grant was on group 8.
8.
But if it gets changed, then I'm affected, right? Then
Okay.
I will oppose
Okay.
this. And it is very fair for government to give a chance for me to oppose this patent, right? But if any changes that I want to make before the grant, then like everything is being discussed with the controller and the examiner, everything is being taken care of, this novelty, everything is taken care, right?
Yes. Yes. Yes.
And because now after the grant, there is no examiner process, no examiners
Okay.
is involved in searching, doing those
Yes.
things.
Yeah.
Therefore,
Yeah.
they simply publish it. Okay.
Okay.
And any affected can approach and ask for, means he can oppose, and then there would be hearing and everything would take place. And then, and that is the process. So it is like government is giving chance to person who may get affected by this change to hear him, right? If government controller does not give this chance, and after the grant also, if I can make some changes, then it is very dangerous, right?
Okay. Yes.
Because
Correct.
as you know, many companies they keep track of their competitors, and they know what are the application get published. So, for example, in January,
Right.
grant got published, and I read that grant is for we claim group 8 metals, and then I said
Okay.
our company is out of danger. This patent is published, this is
Okay.
granted, and it says we claim group 8 metals. And then I no longer track those patent, right? I'm not taking those
Yes.
grant. But suddenly after 3 years, someone from my company sees, he said, "Arey, you see, this says we claim group 7 metals, but you
7
say group
meters.
8 metals. How
8
this is?"
meters.
Okay.
Okay.
So therefore, this should not be the case. Therefore, control publishes it. And now it is the duty of my company to keep a track of any information getting published, right?
Correct.
And
Yeah.
then do it. Okay. So I think we had enough discussion on this. Okay. So it is.
Okay. Yeah.
Anyone has any other doubt?
Sir, it happens clerically, or because we submit the amended specification to the controller, and whatever we submit, it has to get grant, actually in a regular practice. So this amendment after the grant, if we see, it happens clerically, clerical errors, or how it goes
Yeah. So
usually.
before the grant, there are clerical errors, but after the grant also there could be some clerical error that got missed
Yeah.
from examiner, from the drafter,
Okay.
from the inventor,
Okay.
right?
Okay. Okay.
You will
Okay,
see,
sir. Thank you.
mostly it
Yeah.
happens while writing the kg to grams, ml to ml, right?
Yes, yes, yeah, yeah.
Somewhere,
There, it may happen like millimeters, centimeters, some small clerical errors,
correct,
like
correct.
there might be a chance. Okay, sir.
Then
Fine, sir. Thank you. Yeah.
any more questions or any clarification you need? Okay, if there is no,
I just have
yes.
one.
Shravan has posted one question. That is that can we make amendments in claims after the grant? Shravan has
Yes,
posted
yes,
the question.
we can
Yeah.
make changes in the claim, but
Okay.
please don't post in the chat because I don't see the chat.
Yeah.
Okay.
Okay.
I'm in full screen
Okay.
mode now. I don't see the
Yes.
chat. So anything is
Yeah.
there, you can ask. So yeah,
Oh.
you can made in the claim also. Okay, but it has to fulfill these conditions: corrections, explanations, and shall be allowed except incorporation actual facts, or no amendment of complete specification. So complete specification includes everything: examples, claims, and everything it includes. And then we need to keep in mind that amended would claim or describe matter not substance disclosed or shown in specification before amendment. So you cannot make a claim amendment which will be substantially different, and then you will have to justify anything that you want to claim or make amendment. You need to justify why you want to make changes. And again, when we are discussing this amendment of claims, please remember these points, because while in the infringement, okay, when we go for the infringement study, we will see that if you file an infringement case upon some person, okay, and then because of this amendment, that infringement has come in picture, then government will means in the court cases you will be asked about your intent of that amendment. What was your intent amendment? Why you amended this? So many questions will come. We'll discuss in the during infringement. So it should not be like, for example, I filed a patent and I filed with a claim, okay, and then suddenly I see that one person he is out of my scope of the claim, because but if I see that if I make slight changes in my claim scope, then he comes in, he will become an infringer. Okay, so with that motive, intelligently we hire some good drafter, good person knowledge in patent agent, and then he makes those changes in the claims, and suppose it gets finalized by the controller and it is done. Nobody has opposed this, and now you go to court and say, see, this person is now infringing my patent. Then this question will come up again: was this amendment with good intent? How the scope has changed, how the scope has not changed, why he was not infringing earlier, why he has become an infringer after the amendment only. So everything will get now discussed, okay, and then he may invalidate your entire claim, so your patent is gone. So it is, all these things are very need to be done with good knowledge, good understanding, and everything has to be done in a proper way. But yes, we can change the claim and anything in the specification, but these things has to be taken into account. And also when we read the infringement sections, so those things also need to be taken into account. Okay, is it clear now?
Yes, sir.
Okay, so we'll move to next section.
Prem, I just have one question.
Yes.
Actually, the section 57 and 51, one is related to the controller, before controller and before High Court, right?
Correct, yes.
So I just have one doubt. When generally, whatever the request you have to make, it is to the controller.
Mm-hmm.
So when High Court will come into the picture?
Yes, so there are some proceedings which goes to appellate board or the High Court. It doesn't go to controller. For example, for revocations, you will read in the compulsory licenses and in the infringement sections, you will read that it is made to the High Court or sometimes to the appellate board. The case does not go to the controller. Okay, and then there are hearings, and then if it goes to the High Court, then patent agent is out of the question now. Only the lawyers can go and represent in the High Court, because patent agents will read the rights of patent agent also. So patent agents have rights to be present before the controllers in the patent office. But when the case goes to the High Court, we need some lawyers. Okay, so it goes to High Court, and then there is a hearing, and then High Court gives the decisions, and then they say that, okay, this need to be amended, and whatever the case may be, as we discussed. So this is the case when it goes to High Court or appellate board. Otherwise, if there are some changes without any case, without any revocation case, then one can approach to the controller, and then you can ask for changes.
Okay.
Okay.